Hello friends, good evening. Myself, Mohan Vidyarthi, Assistant Professor in IIMT College of Management, Greater Noida. Today we will study about the Payment of Gratuity Act 1972. So let's start. So what is the gratuity? Gratuity word derives from the Latin word gratuitous, which means free or which means gift. So basically we can understand the meaning of gratuity is free gift. So what is the gratuity? Gratuity is the amount paid by an employer for the service rendered by an employee during their employment period. According to the law, employees have the right to avail of gratuity after working in an organization for 5 continuous years. What it means? It means an employee can get their gratuity after working 5 continuous years. Before that, he can't get his gratuity. Generally, it is paid during the employee's retirement, but can also be paid during their active employment years. The Payment of Gratuity Act passed by an Indian Parliament on 21st August 1972 and came into effect on 16 September 1972, and it applies of the following. So, who comes under this act? Every factory, mine, oil field, plantation, port, and railway company, every shop and establishment within the meaning of any law in which 10 or more persons are employed or were employed on any day of the preceding 12 months. Such other establishment or such other establishment or class of establishment in which 10 or more employees are employed or were employed on any day of the preceding 12 months as the central government may by notification specify on this behalf. Wide application only condition 10 or more employees. If the company are less than 10 employees, then it does not come under the gratuity, but it comes under the gratuity if he has more than 12 more than 10 employees in last 12 months. If the number of employees is reduced once this act is applied to a shop or establishment, it shall continue to be governed by this act even if the number of persons employed get reduced at a later date. What it means? It means if a company has 12 employees in the last year and in that year he has come into the gratuity act and now he has 12, only 9 members, then it will then their 9 member will also come in the this act. So, who is the employee? We should understand what is the employee who comes under the Gratuity Act. So, any person employed on the wages, it not considered the apprentice. Apprentice will not consider as an employee. So, any person who is employed on wages in any establishment, factory, mine, oil field, plantation, port, railway company, or shop, or to do any skilled, semi-skilled, or unskilled, manual, supervisory, technical, clerical work, whether the term of such employment are expressed or implied, or whether or not such person is employed in managerial or administrative capacity, but does not include any such person who hold a post under the central government or state government and is governed by any other act or by any rules providing for the payment of gratuity. What it means? It means the all person who works for a company is come under the known as employee. Doesn't matter what his positions, but a person who is working in central government and or state government and providing any other payment or like any other payment equal to the gratuity, then he will not be considered as an employee. After the amendment, teachers cannot be called with the employee due to the amendment of this. Before that, people are also called the employee of the organization, but after the amendment, teachers cannot be called the employee of the organization. So, who is the eligible for the gratuity and when he will be eligible? Gratuity shall be payable to an employee on the termination of his employment after he has rendered continuous service for not less than 5 years. So gratuity will be given after the 5 years on his superannuation or on his retirement or resignation, or third one is on his death or disablement. In this case, it is the exception case. In this case, 5 years service are not required due to the accident or disease. In the case of death of the employee, Gratuity payable to him shall be paid to his nominee, or if no nomination has been made, to his heirs, and where any such nominees or heirs is a minus, the share of such minus shall be deposited with the controlling authority, that is, government officer, who shall invest the same for the benefit of such minor in such banks or other financial institution as may be prescribed until such minor attains a majority. So, if a person is unable to nominate, is unable to make his nominee. So no nominee has been made. Then in that cases, any person who is his heirs will get the his gratuity reward. What will be the gratuity to the disabled employees? Means those employees who has been leave the company because of some disease or accident, but after some time they have been come back. So in that cases, computing the gratuity payable to an employee who is re-employed after his disablement on the reduced wages, his wages for the period preceding his disablement shall be taken to be the wages received by him during that period, and his wages for this period after his disablement shall be taken to the wages as so reduced. So the payment of the gratuity will be taken as the new his new salary. Now we will see how to calculate the gratuity. So the gratuity calculation formula is interdependent on the act and varies according to the following criteria. Basically, there are two types to calculate the gratuity. First one is gratuity calculation for the employees who are covered under the Payment of Gratuity Act 1972, and another one is payment gratuity calculation for the employees who are not covered under the Payment of Gratuity Act 1970. So we can easily see that there are two conditions. Let's see by one by one. First one is calculating gratuity for the employees who are covered under the Act. In that cases, gratuity will be equal to the last drawn salary multiplied by the number of completed years multiplied by the 15 by 6. So what is the last drawn salary? The last drawn salary will be equal to the basic salary plus DA. We should aware that the last round salary will only include basic salary and DA. It will not include any type of HRA or any other reimbursement like TA, newspapers reimbursement or any other reimbursement. It will only include basic salary plus DNS allowance. The number of completed year of service will be equal to the total number of years for which service provided. 15 days will be equal to the number of days the employees has worked, and 26 days the total number of working days in a month. So let's see, let it understand by an example. Alice work at XYZ firm covered under the Gratuity Act and receive a monthly package of 75,000 including basic salary and DA. She has worked in the firm for 7 years and considering moving into a new challenge. So, what will be her gratuity? So, let's see it. The gratuity will be equal to the salary last drawn multiplied by the number of completed years multiplied by the 15 by 6. Now, inserting the values in the formula, we get the gratuity. The last drawn salary by her is 75,000. Number of completed years is 7 years. And the 15 by 6, which is equal to 0.5769. When we put the value in formula, then we get the gratuity total equal to 4,03,846. This will be the complete gratuity will be which will be received by the Alice from his XYZ firm. So it is the gratuity for the employees who are covered under the Act. And what will be the gratuity for the employees who are not covered under the Act? Let's see also that gratuity for the employees who are not covered under the Act. The formula for that for calculating that type of gratuity is last 10-month average salary multiplied with the number of completed year of service multiplied by 1 by 2. So let it understand by an example. Priyank, who work as a marketing executive for ABC Corporation. It is not covered by the Gratuity Act. His salary varies from 40,000 to 45,000 due to performance incentive, and he has completed 12 years of service. So now he is going to be retired. His gratuity amount would around to be 2,55,000. Let's see how. So we can see that the gratuity is equal to the last 10th month average salary. Let the his 10th month average salary is 42,500, which is varies from 40 to 45,000. So the average salary will be 42,500. Number of completed years is equal to 12 years, and it should be multiplied by 1 by 2. So after putting the value in the formula, we get the gratuity is 2,55,000. So we can easily see the differences between the gratuity for the employees who are covered under the act and who are not covered under the. After that, we will see what will happen when gratuity is not paid by the employer. In case employer deny to pay the gratuity to his employee, then what can be happen? So if an employer fails to pay gratuity within the specified period, which is equal to the 30 days after the retirement, the governing authority has the right to issue a certificate of recovery to the collector, but it is also important to give the employer a chance to explain their case before any steps are taken. Penalties like imprisonment and fines can be levied against the employer violating the act with the false claims to escape the payment of gratuity. Employer can also be relieved from his liability if they prove their diligence in enforcing the act and actual offender acted without their knowledge or consent. So what will be to the employer if they are failed to pay the gratuity? Let's see. So what are the penalties? So it depends on their offense. If they given false statement to avoid payment, then the penalty will be 6 month imprisonment or the 10,000 rupees, or it can be both. In other cases, if he default in complying with the act, then the penalty can be changed 3 months to 1 year imprisonment and 20,000 rupees, or it can be both. Third one is non-payment of gratuity. If he denied to payment the gratuity, then the penalty will be 6 months to 2 year imprisonment. Now we will see the tax treatment for the gratuity. Is the gratuity is exempted from the tax or not? So it is categorized in various conditions. So let's see each condition one by one. First one is gratuity is received during the service. If you receive the gratuity during the service, then it is fully taxable. It doesn't matter where do you work. It is covered under the Gratuity Act or not. Are you central employee, state employee, or anything else? If you receive the gratuity during your service, then it is fully taxable. But if you receive the gratuity at the time of retirement or death, in that cases there are two conditions. First one is if you are the employee of the central government or members of civil services or local authorities employees, then you are fully exempt from the taxes. But in case you are other employee, then there are also two conditions. First one is uh, if you are covered under the Payment of Gratuity Act 1972, and another one is not covered under the Payment of Gratuity Act 1972. We see it one by one. If you come under the Payment of Gratuity Act 1972, then there are various conditions, and the list of the following would be exempt. If the gratuity is 20 lakhs, another one is actual gratuity received, or the 15 days salary based on the last round salary for every year completed of the service, or are part of their in excess of 6 months. Number of days in a month to be taken as 26. So which will be the least will considered as the tax exemptions gratuity amount. And in case if you are not covered under the Payment of Gratuity, then there are also some condition. First one is 20 lakh rupees. Second one is actual gratuity received, and third one is half month salary based on the average of the last 10 months salary for every completed years of service. Number of days in a month to be taken as 30. So these are the Gratuity Act. Hope I hope you like it. If you have any query, you can message us. Thank you very much. Have a good day.